The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly-ish podcast on the Courts of Appeals. I'm your host, Robert Everett Johnson, filling in this week for John Ross, and I'm joined by Paul Sherman and Renee Flaherty. This week we have a sign on a stick, a brouhaha over cell phone warning labels, a circuit judge ruminating, and an update from the civil forfeiture hotbed of Tenaha, Texas. But first, this week we're going to do something a little different. Our guest, Paul Sherman, was in Colorado last week for an argument before the Colorado Supreme Court. Paul, why don't you tell us a little about the case?
Yeah, this was a great case, and it's one of the cases, normally when IJ takes a case, we litigate it all the way from trial to conclusion. This was sort of the unusual case where we saw an appellate decision that we thought was wrongly decided, and we swooped in and we were able to take over the case, and we convinced the Colorado Supreme Court to take the case, and I was able to argue it last week. And it's an important case with First Amendment dimensions that relates to political speech. And the issue is whether pro bono legal services can be considered political contributions under Colorado law. Now, this is an extremely important question because Colorado has notoriously complex campaign finance laws, and people often rely on pro bono legal help to navigate those laws. What the Court of Appeals had held was that pro bono legal help qualifies as a contribution under the law, and that has significant consequences because that means that not only do you have to try and keep track of and report the value of the pro bono legal help, but if you're a group that's subject to contribution limits, there's a cap on the amount of pro bono legal help you can receive. So this was an important issue, and we were excited to argue it.
And we first got involved in Colorado because of a peculiar feature of their campaign finance laws. Anybody in Colorado can enforce the campaign finance laws. Not just the government. Is that right?
Yeah, that's right. So in most states, if someone thinks that you violated the campaign finance laws, they can file a complaint with the government, and the government will investigate the complaint. And if they think there's some merit to it, then they might move forward with legal action. What Colorado has done is they have outsourced all of their campaign finance enforcement to the public at large. And so anyone who wants to can file a private lawsuit to enforce the campaign finance laws. And this has worked out exactly as you would expect it to. These lawsuits are routinely filed, not because people are legitimately concerned with enforcing the law, but because they want to harass or intimidate their political opponents. So we've actually litigated campaign finance cases in Colorado since way back in 2006. This case is a perfect example of that sort of thing. In 2012, our client, a group called Coloradans for a Better Future, ran some ads criticizing a candidate for the Colorado Board of Regents named Matt Arnold. Matt Arnold lost the Republican primary, and after he did, he turned to the courts, and he has filed either personally or through a group he founded called Campaign Integrity Watchdog, 4 consecutive lawsuits against Coloradans for a Better Future, each alleging increasingly picayune violations of the campaign finance laws. And the most recent was that in order to escape this harassment, Coloradans for a Better Future, with the help of a volunteer lawyer, shut down. They filed a termination report with the Secretary of State, and this prompted a 4th lawsuit alleging that the volunteer lawyer's time was a political contribution that should have been disclosed. Remarkably, the Court of Appeals bought that argument, and so that's when IJ stepped in. So we had a great argument before the Colorado Supreme Court, and we expect we'll get a decision within 3 to 4 months.
Yeah, so this is sort of an unusual argument where we're representing a client that doesn't exist anymore. And the opposing counsel is enforcing the campaign finance laws, but it's not the government. It's a private citizen.
Yeah, and it really goes to show how vindictive these laws can be. We're talking about disclosures that are related to an election that was over in 2012. There's no possible public interest in knowing, what's the value of the legal services for this defunct group to shut down in 2015. But for a lot of these litigants, it's not about actually providing a serious public service. It's about getting revenge on people who they disagree with politically. We are actually challenging the private enforcement system in federal court currently. And so our hope is that eventually we'll just have that system struck down entirely, and that will disarm these people who would use the law against their political opponents.
And for the pleasure of our listeners, we have a clip from last week's argument. Let's go ahead and play that now.
What I think this discussion is bringing out, though, is that Colorado's campaign finance laws are extremely complex, and they are filled with traps for the unwary. And so the decision below creates a double harm, because not only does it create a new trap that is by no means apparent from the text of the statute, but it deprives political speakers in Colorado of the one thing that they need most to navigate these traps, and that's access to free or reduced cost legal services. There is no basis for that outcome anywhere in the text of the statute, and so we respectfully request that the decision below be reversed.
Yeah, so that was supposed to be the dramatic conclusion to my argument, and I was really proud of having put that together. I thought it really put a bow on the argument. What the clip doesn't reveal is that right after I delivered that dramatic conclusion and was ready to sit down, one of the justices said, Mr. Sherman, I have just a few more questions for you. So it wasn't quite the capstone that I wanted, but overall, we were very happy with how the argument went.
And you think the judges agreed with you?
It's always dangerous to make predictions based on oral argument, but I think we have an exceedingly strong case, and the argument went very well. So, if I were a betting man, I'd bet that political speech in Colorado is going to get a little freer.
All right. Well, why don't we jump into this week's cases? Renee, you want to start us off?
Thanks, Rob. So first we have a Fifth Circuit case. It's a criminal appeal, and I always like coming on Short Circuit because it means I get to read criminal cases, which I don't do as a civil lawyer. But this case actually does sort of tangentially relate to something I do, which is civil forfeiture. A long time ago, there was an article in the New Yorker about civil forfeiture called Taken, and it told the story of a family who got into the civil forfeiture trap in Tenaha, Texas. They were driving to a town near the Louisiana border to do something that is literally the most innocent thing I can think of, which is traipse through a field of wildflowers. And they were also going to buy a used car, so they had $6,000 in cash with them. And they were stopped by the police, and the police took their cash and threatened to take their kids away and charge them with crimes if they didn't hand the money over. And it turns out that Tenaha was doing this to everyone. They had kind of a huge setup here and were making a lot of money. But also, there was a lot going on in Tenaha, and that brings us to this Fifth Circuit case, which is an appeal of a criminal conviction of this guy named McClure, who was conspiring with the city marshal to steal drugs from the evidence locker and sell them. And he was a convicted felon, and he had a bunch of guns in his house. And so he also was appealing a conviction for felon in possession of firearms. And these two cases were kind of related, but not really. And there was a plea agreement in one of them. And the Fifth Circuit case was about whether that plea agreement sort of precluded him from being prosecuted in the other case. And the panel said no. And I think it was a pretty straightforward case, but it was a little hearkening back to the lots of corrupt things going on in Tenaha, Texas.
Yeah, I think one of the interesting things about this case, Renee's right, I think that as a legal matter, the issue of whether this plea bargain precluded this, prosecution for other bad ideas was very straightforward. But I think it shows that when you let a system as abusive as civil forfeiture go on, it just breeds this deeper level of corruption. I mean, the facts of this case are extraordinary. Like, you've got evidence that this guy McClure was also acting on orders from the police to bug the mayor's office so that they could monitor this investigation related to the civil forfeiture. Unfortunately, I think it's not just a matter of these are some bad apples. I think this is a system, civil forfeiture is a system of terrible incentives that basically turns the police into criminals.
Yeah, that's exactly right. And it really just shows this is why we have the protections of the criminal law, because you never know who's going to be prosecuting you, who's going to be going after you. And it's a protection for citizens that before the government can take your stuff because you did something wrong. They have to convict you of a crime. And when you take that protection away, you're exposing people to the whims of the police department of Tenaha, Texas. It's a very dangerous thing.
Yeah, I mean, luckily, and I think we can say this with without false modesty, because of a lot of the work at the Institute for Justice, there's a lot more public awareness of these issues related to civil forfeiture. Things like the story in the New Yorker, and so hopefully, as these horror stories come to light, eventually we'll see both more legislative reform, but also more courtroom victories that will pare back this practice.
Well, I think we're already seeing that, and hopefully it'll just continue. So why don't we move on now to signs on sticks?
Yeah, so this is a case. It's kind of an interesting quasi-First Amendment case, quasi-due process case involving the Iowa State Fair. This gentleman named Jason Powell wanted to attend the Iowa Fair, and he wanted to stand on the sidewalk holding a large sign on a pole with a religious message. And after he'd been standing there for a while, the police showed up and told him that he had to leave and that he was breaking the rules. They didn't tell him which rules. And he subsequently found out that they had an unwritten rule, both about impeding people getting into the fair, and also an unwritten rule prohibiting signs on sticks or poles. The argument being that the sticks or the poles might be used as weapons. It's an interesting case in part because his argument is that these unwritten rules are unconstitutionally vague, and it's not clear to me how a rule that doesn't even exist on paper can be described as vague.
And the majority says something interesting here, which is that normally rules have to be subjected to a certain amount of scrutiny to make sure that they are clear and understandable. Which an unwritten rule would seem to be the least clear and least understandable of any kind of rule. But the majority casts some doubt on whether that applies here. They say, is that really necessary for the rules of a state fair?
Yeah, and it's I hate to use the word sophistry, but I really can't think of a better word for describing it. So what the majority argues is that if a law imposes criminal penalties or civil penalties, then we require a certain amount of precision from it. But this rule doesn't impose either criminal or civil penalties, because the only thing that it triggers is that you'll be asked to leave the fair. What they sort of ignore is that if you return to the fair at that point, you can be arrested for criminal trespass. But they treat that as if that's just totally unrelated to the fact that you may have been ejected for violating this vague, standardless rule. Luckily, there is a dissent that calls them out on that.
A concurrence, just to be clear.
Oh yeah, I'm sorry. It's a concurrence. So the judge who's concurring. So this case arose on a motion for preliminary injunction. So it's not gotten to the merits, and the judge concurs that the plaintiff in this case isn't entitled to a preliminary injunction. But he does think there is something to his due process argument, and this idea that being arrested for criminal trespass is somehow unconnected to this potential violation of your right to be at the fair just doesn't hold water.
Yeah, and the concurring judge says he's still not entitled to an injunction because he hasn't shown that he's actually irreparably harmed. I don't really see how that follows, since he can't talk at the fair. It seems to be a form of harm.
Yeah, and so for our listeners who may not be as familiar with kind of what a preliminary injunction is, basically when you get involved in litigation, one of the things you can sometimes do is go into court and say, while we're fighting out the merits of this case, I want to be allowed to continue engaging in this conduct. So this very often happens in free speech cases where someone's speech is prohibited. They say, hey, I want to engage in this speech while this case goes forward. And so what the judges suggest in this case is that while burdens on First Amendment rights are irreparable harm, burdens on your due process rights or other constitutional rights are not irreparable harm. And I actually don't think the case law is as good for them on that as they suggest it is. There's certainly case law from other circuits suggesting that any violation of your constitutional rights, even for a limited amount of time, constitutes irreparable harm. So I don't think this guy got quite a fair shake, but it's not the end of the case. He gets to go back and litigate this on the merits, and maybe he will ultimately prevail.
And maybe he'll be back here on Short Circuit.
He seems like the type who is prone to appeal, so I'm sure we'll be hearing from him again.
All right, Renee, do you want to tell us about this Second Amendment case out of the Ninth Circuit?
Sure. So the Fisher case is, I think, a pretty straightforward case of statutory interpretation, but it also does touch on this really interesting Second Amendment issue that Judge Kozinski gets to ruminate about. And I'm not sure if that's a common thing that he does. I assume it means a concurrence, but I think it also means that if you're a federal circuit judge, you get to do whatever you want.
Yeah, just for the listeners who can't actually see the opinion, right? So there's the majority opinion, and then there's a second opinion at the back from Judge Kozinski. And normally you'd say Judge Kozinski concurring or Judge Kozinski dissenting. This one says Judge Kozinski ruminating.
Yeah. And this is actually not the first time he's done this, though. There's a Judge Kozinski disagreeing with everyone, so there are a handful of federal judges who do this. Judge Easterbrook has done a Judge Easterbrook dubitante, which means like he's dubious of the result. So anyway, Renee, what was Kozinski ruminating about?
Well, I think he was right to ruminate. This case was, a statutory interpretation case. It was a challenge to a Hawaii statute that incorporated federal law that banned anyone who had a domestic violence conviction from possessing firearms. And Fisher, the plaintiff, had an old domestic violence conviction from 1997, and he challenged the statute because his conviction was old. He hadn't had any more convictions since then. And he also said that because Hawaii only provides one method for someone like him getting their rights back, which was a pardon by the governor, that this statute couldn't constitutionally, exist in Hawaii because there are 4 different ways listed in the statute that you can get your rights back. And he was saying that those 4 ways are a precondition to the statute operating, but the panel disagreed and said that no, they're not preconditions, they're just exceptions. And so it doesn't mean that a state has to have all 4 different ways of getting your rights restored for the statute to be constitutional. And also that since Fisher hadn't actually tried to get a pardon from the governor, that he couldn't challenge the constitutionality of that.
He can get a pardon from the governor, though, and Kozinski suggests maybe that's not good enough. Yeah, why is that?
What's troubling about this is that, the pardon power is the most standardless and, it's the ultimate act of discretion on the part of the executive. And normally when people's constitutional rights are at stake, we don't say that their enjoyment of those rights can turn on something that's totally standardless. We like in the First Amendment realm, for example, that's just like the hallmark of an unconstitutional prior restraint is when your right to speak turns on some official's standardless discretion. And it really shows, I think, that Second Amendment rights are being treated as second-class constitutional rights.
Yeah, and Kozinski says that his last sentence says it's time to treat the Second Amendment as a real constitutional right. Which I think gets at something we talk about here on Short Circuit all the time. This idea that in the courts today you have some constitutional rights that are treated as real rights and some that aren't, like the Second Amendment or your right to economic liberty. And part of what judicial engagement means is saying that all constitutional rights are real rights and deserve real judging.
Yeah, I think it also highlights the power of federal appellate judges. I mean, when we think about the judiciary and we think about judicial nominations and confirmation, most of the public attention and the media attention focuses on the U.S. Supreme Court. And that's really a mistake because the U.S. Supreme Court decides about 75 cases a year. It receives thousands of petitions a year and rejects them. And so most of the time, judges of the federal courts of appeals have the final say. And I think what we've seen particularly in the Second Amendment area is that there's a lot of judges in the courts of appeals who are resistant to decisions like the Heller decision and the McDonald decision on gun rights. And so they're taking an extremely narrow view of those rights, possibly with the hopes that there's a change in the composition of the Supreme Court. But the Supreme Court can't take all those cases. And so, to the extent that that's an issue you're concerned about, paying attention to nominations on the federal courts of appeals is important.
Yeah, I mean, if for that issue or any issue,
Yeah,
it's
absolutely
true
right.
for almost
Absolutely
any issue.
right.
All right. Well, so our last case is another one out of the Ninth Circuit. Paul?
Yeah, so this is a very important First Amendment case being litigated by some real heavyweights for the plaintiffs, which is an association of cell phone manufacturers and retailers, were being represented by Ted Olson, former Solicitor General. The defendants, the city of Berkeley, California, being represented by former presidential candidate and Harvard Law School superstar professor Lawrence Lessig. And the issue is an ordinance the city of Berkeley passed that requires cell phone retailers to include a disclosure whenever they sell a phone to somebody. And I'll read the disclosure to you. This has to be it either has to be on an 8.5 by 11 piece of paper in large font, or you've got to put it on a card in like 18 font. The city of Berkeley requires that you be provided the following notice. To assure safety, the federal government requires that cell phones meet radio frequency exposure guidelines. If you carry or use your phone in a pants or shirt pocket or tucked into a bra when the phone is on and connected to a wireless network, you may exceed the federal guidelines for exposure to RF radiation. Refer to the instruction in your phone or user manual for information about how to use your phone safely.
This sounds terrible. I don't know about you, Renee, but if I heard that, I would not be carrying my cell phone around in my pocket.
Yes, and definitely not my bra.
Yeah, and so particularly the line about bra, I think like you hear that and you think like if I carry like a phone in my bra, am I gonna get cancer? And so the retailers were very unhappy about this, and so they filed a First Amendment claim. And what they said is this is a form of compelled speech. Compelled speech has to satisfy First Amendment standards. And this is highly misleading. It makes people think that these phones are unsafe, and there's no evidence that they are. And the city defended, and they said, look, every sentence in this warning is literally true. The federal government does require that cell phones meet certain safety requirements. If you carry a phone next to your skin, you may exceed those requirements. And the federal government also requires that cell phone instruction manuals have safety information. And so the Court of Appeals agreed. And the Court of Appeals looked at each of these sentences in isolation and said, under the applicable standard that applies to compelled speech in the commercial context, each of these is true, and the government has a substantial interest in, promoting consumer awareness and public safety. I think this is exactly the wrong approach, and I think the dissent in this case gets it exactly right, which is that you can't look at these statements in isolation. You have to look at the total impression that's conveyed. And I think the clear impression that is conveyed is that carrying a cell phone in your pocket or against your skin is unsafe. And that's just not true. The city made no effort to prove it. And in fact, if you go to the FCC regulations, what's clear is that the FCC set standards for RF radiation that are many, many times more conservative than any safety consideration could require. They actually state that you would have to exceed these standards by like 50 times in order to even create the possibility of harm from a cell phone. Now, the difference in distance that we're talking about here for exposure to the cell phone. So these guidelines were first written in 1996. And at the time, the FCC, being very fashionable, thought that folks were going to wear their cell phones exclusively in holsters on their belts. No one does that anymore, except maybe some of our listeners' fathers and grandfathers do that. But the assumption was that cell phones would be carried at least 5/8 of an inch away from your body. Now people carry them in their pockets, so they're 5/8 of an inch closer. The difference in radiation, in radio frequency radiation exposure from this is trivial, but it can cause them to exceed this limit. But there's no evidence that that makes the phones dangerous. This gets to a very important First Amendment issue, though, that does not just apply to cell phones. It applies basically everywhere, which is when can the government force you to make additional disclosures about your products?
Well, and that's an interesting point, right? So the Supreme Court case on this, Zauderer, has an interesting line where they say that the government can require disclosures of purely factual and uncontroversial information. And the opinion here is all about whether this is purely factual or not. And that second part, uncontroversial, just seems to drop out of the analysis.
Yeah, so Zauderer was a case about lawyer advertising, and it was a lawyer who he said in his ad, "I'll take your case on a contingency fee basis. If you lose, you don't owe any fees." And there was a bar rule that said that this was misleading because even though you might not owe fees, you might owe legal costs like court filing costs and things like that. And so what they required was an additional disclosure to correct that misimpression. And the additional disclosure was purely factual information. So there are kind of two things that have gone on in the courts since then. One is this question of, does Zauderer only apply for the purpose of correcting misleading speech? And unfortunately, the Ninth Circuit here holds that it does not. And that basically any time the government thinks it has a good enough reason, it can require a manufacturer to disclose additional information. And then the second thing is, what is this? What does it mean for speech to be uncontroversial? Here, the court collapses whether speech is uncontroversial into whether it's truthful, even though obviously the impression created by this speech is that these phones are dangerous, even though each of the single sentences is conceitedly truthful.
Yeah, and there's sort of an odd aspect of this, too, which is that the whole point of the First Amendment is that whether something is true or not is something that's to be determined by the listener, not by the government. And so what does it mean for the government to be requiring disclosure of true information?
Yeah, and I would say an even bigger problem here is that a rule that allows for these kinds of disclosures is going to create a lot of politically motivated junk disclosure that doesn't actually help consumers. And in fact, this is something the dissent talks about, that if we have this proliferation of warnings everywhere, eventually people start ignoring the warnings. And maybe it would be better for us to allow consumers and retailers who have a legal interest in making sure that people know about the risks of their products to make those decisions themselves.
That absolutely seems right. And I think, this is such a bad decision from the Ninth Circuit that it wouldn't surprise me to see this going up to the Supreme Court, particularly with the lawyers who are litigating this case. So this may not be the end of the road.
There's a lot of litigation on mandatory disclaimers, and I think that this is a likely case for a cert petition.
All right, well, that concludes this week's show. Thank you for listening. I'm your host, Robert Everett Johnson, politely suggesting that you get engaged.